Welcome. My name is Rupert Warren QC. I've just chaired Christopher Young, Queen's Counsel's paper at the Oxford Planning Conference this year. He gives the case law update for 2018, the staple diet of the Planning Conference, always held at the end of the event so as to ensure maximum attendance throughout. And today was no exception. Chris's paper is entitled Legal Update in a Post-Suffolk World, and many of you will be familiar with the Suffolk or Richborough case and why perhaps Chris has entitled his paper in that way. Welcome, Chris. Can I ask you perhaps to begin by just touching on that point? Why have you called your paper a post-Suffolk world?
Yeah, well, I think we have a lot of cases coming from the Planning Court and an increasing number from the Court of Appeal. But obviously, the Court of Appeal is sitting below the Supreme Court, which provides guidance only a few times a year. And the Suffolk coastal case, I think in particular, saw the court handing down some significant observations about the planning system at a time when the Planning Court is frankly struggling with the sheer volume of cases that are now being brought in light of the Tesco and Dundee Supreme Court case in 2012.
Yes, and in the Suffolk decision itself in the Supreme Court, were there, other than dealing obviously with the legal issues which were in play in the case itself, any general statements that emerged that might be of interest to delegates of the conference?
Yes, I think so. I mean, I think as I've suggested, there are really as many as 10 principles that the Supreme Court handed down. Particularly noteworthy, I think, was the emphasis on the over-legalisation of the planning process and unnecessary scrutiny of planning decisions as if they were statutes, and to look at policy and decisions as well in the context of looking to see what the overall outcome was. So in particular, Lord Carnworth emphasised we need to respect the expertise of the specialist planning inspectors and to start at least from the presumption that they've understood the MPPF or indeed any policy correctly, and there would be issues of genuine interpretation for the court to deal with, and they're particularly concerned with the need for consistency of interpretation. But when doing that, don't be hypercritical of inspectors' decisions. And in addition, look at the natural language that's used in the wording of policies, because some of the case law that led to the Supreme Court case involved some creative, we might say, use of particular policy wording to achieve certain outcomes.
Yes, it's interesting, isn't it? Because it seems to me that especially where inspectors' decisions are concerned, there's a continuity between what Robert Carnworth was saying in the Supreme Court and the general principle of deference to expert tribunals that you get more and more across all of public law. I mean, one of the problems perhaps is Secretary of State decisions where there's more politics involved, perhaps.
Yes, I think that's very true. I think we've seen a very significant number of successful legal challenges to cases involving neighbourhood plans. I think we're up to about 8 challenges in the last couple of years. And in addition, just inconsistent decisions from the Secretary of State, which in some of the other cases, like the DLA case and Hallam Land, has led certainly Lord Justice Lindblom to observe that perhaps the DCLG, now the Ministry, should be doing more to ensure their own decisions are consistent.
Yes, I mean, that's a problem that doesn't ever seem to go away, does it? Going all the way back to decisions 10 or 12 years ago where Andrew Gilbart, for instance, weighed in, didn't he, on the same point?
He did, exactly. You're thinking, obviously, of the Fox Land case. Richborough had been successful, Gladman had been unsuccessful 500 metres away, and the consequence of that was that Andrew Gilbart, I think, suggested, didn't he, that you should have them all in one inquiry.
Yes, absolutely. And certainly when they're all sitting in the same room now at Marsham Street, there's little excuse for making inconsistent decisions.
Yes, well, perhaps this time, several decisions of this kind, it will be heeded.
Can I ask you one other thing about the substantive points that you deal with in your paper on directly challenging policy content rather than the way that decisions are made. And have there been any big cases on that in the last year?
Yes, well, I think that there's your own case, obviously, the successful challenge to the Mayor's policy on affordable housing, where although the court was very critical of some of the detail in considering issues of whether matters of policy and guidance, nevertheless, there was inconsistency there. And so challenges of that kind are still very legitimate to the content of policy. But one that was less successful was as you know, the challenge to the written ministerial statement on neighbourhood plans, where the High Court, Mr Justice Dove, very much followed the line of the Court of Appeal in the West Berkshire case, challenge to the written ministerial statement on affordable housing, where the court was very clear to say challenges to the content of policy will be exceptional. They'll be very unusual in terms of being successful. And in particular, it's the case that ministers will be given wide discretion to write policy in whatever terms they see fit.
Chris, I suppose one other topic that's always of interest and isn't, again, likely to disappear in the light of changes to the new framework and to the way that Historic England publishes its guidance, is how you go about looking at heritage assets and their settings. And there has been, I think, a Court of Appeal case on that in the past year.
There has. I mean, this issue never really seems to go away. The courts have emphasised how important this is in light of the statutory requirements in the Listed Buildings and Conservation Act. The issue that seems to come up more often than not, in my experience, is the issue of the setting of listed buildings. And of course, the case that you did for Catesby, successful at inquiry, quashed in the High Court, but then that decision reversed in the Court of Appeal, where the inspector had looked in particular, although not exclusively, at whether there was a physical or visual connection between the proposal and the listed building. And although the High Court was critical of that focus, the Court of Appeal, I think, reinstating again some of the Suffolk coastal principles, respecting the inspector's decision, avoiding hypercritical scrutiny, took the view the inspector had taken a perfectly acceptable approach, and that the physical and visual connection between a new proposal and a listed building was a relevant and important factor, although not the exclusive factor to look at.
Yes, and in that case, I recall Lord Justice Lindblom asking me whether Suffolk Coastal dicta had been excited to Mrs Justice Lang first instance, so that he could be absolutely sure that it had been fully taken into account by her rather than just imposing it. Do you think this has settled the approach to setting? Does it still leave things unaccounted for?
I think there'll always be issues about it. I think when there's any proximity, particularly on an estate where there's a very large area that's potentially within certainly the historic setting, that will continue to have these issues. I think what's possibly even more significant about the case is just this re-emphasis about respecting the inspector's decision. I think that's very much what drove the decision there, and clearly, Mrs Justice Lang came to a different view about whether the inspector had approached it. I think there's a real emphasis from the Court of Appeal on respecting the approach the inspector has taken without criticising every aspect or focusing on a particular sentence that may be the springboard for challenges that we've had in the past.
Yes, just to note, there is a permission application to the Supreme Court in Steer still to be determined, but given what you've said, Chris, in terms of how that decision was actually reached and the focus in the decision on reading the words of the decision letter rather than anything in principle, that perhaps may not succeed, but we'll have to wait and see.
Certainly you will.
Thank you very much, Chris, for giving us the benefit of your expertise at the coalface on these cases in the last year. We're grateful to you.
Thank you.